Aging Insight, empowering you through the aging process.
One thing, and the first thing is a lot of people will ask about, I even got asked about it today, is, what kind of rights do grandparents have? Especially as it relates to those grandchildren. Well, the short answer is none. All right, so end of speech, right? That may actually sound a bit strange, but you can thank the Supreme Court for it. There was a husband and wife, and they were married. They had a couple of kids. They divorced. The husband, he ended up. I don't think the husband was a great kid. But he ended up going back home and living with his parents, and after the divorce, mom had custody of the kids, but then they would share custody with the son, and the son was living with the grandparents, and so the kids would be over at the grandparents' house, every other weekend, that sort of stuff. This went on for about 3 years until the son committed suicide. And so now he's dead, and for a few months following his death, the surviving mama, the mama of the children, she kept up the same visitation schedule. About every other weekend or so, she would bring the kids over to stay with the grandparents for a couple of weeks, month, 2. But then the mama just said, you know what, never mind, we're done. Not going to let y'all see them anymore. And so they filed a lawsuit, the grandparents, the deceased father's parents, they filed a lawsuit saying, we want visitation. Since our son is deceased, we should have the same visitation that our son had. We should step into his shoes. And at the time, I believe this was in Ohio, and Texas, Arkansas, and almost every other state had similar laws to what these laws were. There was a whole set of statutes that provided that, in a situation like this where the child was dead, that the grandparents could step in and exercise the parental rights of that deceased child. And so when the grandparents filed that, they won. The mother appealed that. So they went to the state appeal court where the grandparents won again. The mother, obviously clearly determined here, appealed that to the state Supreme Court, where the grandparents won again. And then they appealed it to the United States Supreme Court. Now, it's unusual for a family law case to ever end up in the Supreme Court, because the Supreme Court has one job, and that is to make constitutional decisions. That's their whole job, to interpret the Constitution. And there's nothing in the Constitution about parental rights and all of that. That's all state law. And so for this to even get to the Supreme Court, for them to even look at it, was unusual at the time. But ultimately, what they came back and said was that the right of a parent to determine who their kid hangs out with is of constitutional importance. That in all of those provisions in the Constitution, that the right of free association and the right to do what you want and all of these sort of things, that parent-child relationship has that constitutional protection. And so basically the Supreme Court came back and said, as long as there is a parent and that parent says they don't want you grandparents hanging about, and that's what happens. And in one decision just like that, almost every state in the United States that had laws about grandparents' rights went away. This happened while I was in law school. So not all that long ago. I took a course in family law. We had an exam that included questions about grandparent rights. And had to know the statutes and know the circumstances and whether, the child had to be deceased and all of these other things. And by the time that class was over and the next semester started, everything in that class was wrong because of this one Supreme Court case. So as a general rule, when people say, hey, what kind of rights do grandparents have? The short answer is none. Now, there can be other circumstances. Let's say both parents are deceased. Okay, well now we don't have a parent to make that decision. So now you can get into a situation where grandparents could step in because there is no parent. So that constitutional protection there is gone. The other thing is if you've got significant contact with the child. Here's what that means. If you as the grandparent have been taking care of that child pretty much on your own for at least 6 months, now you've got, according to the law, you've had so much contact with the child that you step into that position. Let me give you an example of how that works in reality. Lisa Scholmeyer had a family come in, and their grandchild had been living with them for a month or two. The parents were both drug users, and they were off doing their drug user thing. What the parents were coming in about was they had, of course, been giving money and stuff to the kids, helping them with rent and stuff like that, but they wanted to cut that off. And of course, when they suggested cutting that off, the biological parents said, well, we'll just come pick up the kid and take the grandkid back. And so, the parents were coming in wanting to get grandparent rights, since they were taking care of the kid. The problem is they'd only been there for about 2 months. So essentially, what the answer to that question was, and this was from Lisa, she told them, how much grandkid worth? Because basically, you need to buy them for about 4 more months. So those kids need money, give them the money. Are they going to use it for drugs? Absolutely. Are they going to blow it? Heck yeah, they're going to blow it. But think of it this way. How much is the grandkid worth? Because you're going to have to buy them. Because you've got to keep them in your possession for that 6-month period. After that 6 months, you can come back, we can file for grandparent rights, and we'll have standing, and we'll be good, and we won't just get kicked right back out the front door. But you're going to have to get that far. Now notice, that's where the grandparents, they had sole custody of the kids. In the Troxel case, the Supreme Court case, the grandparents tried to make this same argument. They said, look, we've had the kids for visitation and stuff for 2 years, 3 years. So we've had all of that same contact with the children. And the Supreme Court answered that, and they said, well, you're right, you did, but that was only because the son was living there with you. And so you weren't doing it on your own, you just happened to be in the same house where the biological parent was. So that doesn't count. So you've got to actually have that possession of it. So grandparents' rights when it comes to the grandchildren and just being able to take over for those kids, ain't much out there. There can be those little situations. Both parents are deceased. If both parents are having their parental rights terminated. So, where you'll see where if you want to see some really awful stuff, show up at one of the courthouses when they're doing Child Protective Services Day and, listen to the stories of the parents there, trying to explain why their, 3-year-old had a crack rock in his school book, But in those cases, what the courts are sitting there about to take those parental rights away. Once the parental rights are removed, now grandparents or anybody else can also step in. So it's those situations where it's really tragedy situations. But if there is a surviving parent, you pretty much ain't got nothing. All right? That's not good news. I'll give you some more bad news. Donald Trump gets more Social Security than you do. Donald Trump gets more Social Security benefit than you do.
I thought he just got $1.
Nope, Donald Trump actually gets, on top of his regular Social Security benefit, he gets an additional $12,000 every year. You know why? Barron Trump. Barron is a minor. If you're receiving Social Security benefits and you have a minor child, you get extra Social Security to help support the minor child. And in Donald Trump's case, that equates to a little over $12,000 a year. That's $1,000 a month in extra Social Security benefit because Barron Trump is what, 9 or something? 10? Yeah. Why do I say this? We had a lady here recently, and she is actually taking full care of her great-grandchild. And of course, she's on she's in her 80s. She's got a limited Social Security budget, and she's providing 100% of the support for this great-grandchild. Carrying him to school every day and buying the groceries and everything. One of our suggestions in this situation was to see if the parents would agree to allow her to adopt the child. Because if she could adopt the child, then that would be her child. And the minute we got that adoption approved, we can go back to Social Security, and she gets an extra couple of $100 a month. That makes a huge difference. And given her age, it's also possible that she will pass away before that child becomes an adult. And if she passes away, the child will get a survivor benefit. Just as if the biological parent of a child passed and the minor kid gets a Social Security survivor benefit, the same thing works in an adoption context. So, if you do have that minor grandchild or minor great-grandchild, depending on the family relationship, not only may it make sense to, try to get grandparent rights if you've got the right facts, but it may also make sense to adopt the child if that's possible. Now, generally speaking, to adopt a child, you have to terminate the rights of the biological parents. And so if they're cooperative, that's no problem. If they're not cooperative, then you're back to, that's a Supreme Court, U.S. Constitution protected right, and it's going to be very hard to terminate a parent right. There's no law that says you have to be a good parent. And so there's lots of bad parents out there, they still get to be parents. Just like there's lots of bad citizens out there that still get to be citizens, because it's a constitutionally protected deal, right? I was actually talking about this one day, and I realized that halfway through the talk that I had missed a fantastic opportunity. Now, I have lots of clients that will come into the office and they'll say, Dad's been at, assisted living for the last 3 years. It's cost $200,000 and we're about broke. And in the context, I'll say, well, was your dad ever in the military? And they're like, well, yeah, he was in the military. And I'm like, oh, well, are y'all getting the veteran benefits to help pay for that? And they're like, what veteran benefits? And all of a sudden, these folks have realized that there was an extra $1,700 a month they could have been getting for the last 2.5, 3 years that probably would have prevented spending that $200,000. And it's too late, right? You've already spent the money, so we're kind of done on that. So, I kind of like to pride myself on knowing about stuff before it happens. But on this, when I was giving this talk on the whole Social Security deal, I realized I had missed out on an opportunity. What I should have done was, because we've got kids, I've got kids, right? What I should have done was, when I had my kids and my parents over there were Social Security age, I should have had my parents adopt my kids. Because between the two of them, we probably could have pulled an extra, somewhere between $10,000 and $15,000 a year per child. If we'd have done that when those kids were 5 or 6 years old, we could have taken that $15,000 a year and we could have stuck that over in some investment accounts and let that money just pile up year after year after year. And now that those kids are, coming into adulthood and have expenses like college and stuff, man, it'd be done. We'd have a pile of money right there. Completely missed out on that opportunity. Now that I actually don't see any reason why that wouldn't work. I've never tried it. If one of y'all want to be a test case, let's go for it. So you got some minor kids, you want to try to come up with a creative way to generate some extra money. I think it'll work. I don't see any reason why it won't. Like I said, Donald Trump getting an extra $12,000 a year. Ain't no reason why you can't get an extra $12,000 a year. Of course, knowing what I know now, if I'd have had my parents adopt the kids, I might have just fled the country. That'd be their problem now. I'm out. Anyway, so you don't have much in the parental rights, but if you've got some parental rights, you might consider the whole adoption thing. That can bring in some extra money, could be a huge benefit to the kids, could be a benefit to your finances, especially if you're covering all of those costs. But those are all bad situations. Most of the time when people are talking about their grandkids, they're just talking about wanting to possibly include them in their estate somehow, maybe provide for their college and things like that. I'll talk about that in a couple of different ways. One, let's talk about college. Lots of grandparents would like to help contribute towards the cost of college. And I've had many of them over the years who, when their grandchild or great-grandchild was born, or sometime they set up maybe a little college fund for that grandchild, and they threw some money in it. Maybe they've thrown quite a bit in it over time. When a student goes to college, their ability to get any financial aid is going to be based in two parts. It's going to be based on how much in assets the child has and how much in income and assets the parents have. And it doesn't take much for parents' income and assets to blow that kid out of the water for any form of financial aid. I've talked to lots of folks that are my age who have kids my age who are just regular old folks working day-to-day 9-to-5 jobs, but when they applied for financial aid, the financial aid people came back and said, you're not eligible for anything. At least not any of the stuff that you don't have to pay back, the free stuff. Now, they'll certainly give you loans for whatever. I've got one client whose child has $500,000 in student loans. So they'll give you a loan for anything. That's not what I'm talking about. I'm talking about the money that you don't have to pay back, like the Pell Grants and that sort of stuff. And part of that is because the way the financial aid people look at it is the parents, their 20% of their income is what the feds think that they can contribute towards the cost of that college. Well, you don't have to make very much money for 20% to blow you out of the water. So many people are already don't get that. But even the ones that do, I have had where the grandparents had set up this college fund. And that college fund is either in the biological parent's name or it's maybe even in the grandchild's name themselves. In which case, when they go to apply for financial aid, that asset is going to be counted against them. And so instead of getting Pell Grants or stuff like that, they're getting, the government says, well, nope, your grandparents are paying for it. You don't need our money. If you're the owner, if you as the grandparent or great-grandparent is the owner of that college account, even if it's designated for that child, but if you're the owner, it does not count towards financial aid. So if you're talking about setting up college accounts for grandchildren or great-grandchildren, something like that, keep it in your own name. Don't put it in the kids' names. Certainly don't put it in the student themselves' names. And the other thing is, when you take money out of a college account and give it to the student, that's considered income to the student. And so, of course, the student's income can also affect their eligibility. So even if it's in just your name, if you use it to pay for that first semester, then when they apply for financial aid, again, they have to count all of that as income, which is going to knock them out for financial aid the next time. But there's a little way around this as well. The way the financial aid people look at it, when they're looking at the kid's income, they look at the year prior to the year prior. So if you're filling out financial aid for the upcoming 2019-2020 school year, they're going to be looking at the child's tax return for 2017, the year prior to the year prior, right? So, you've got it, you got that college account, it's in just your name, which means when they apply that first year, it's not going to have any effect. You're also not going to use any of it. Not yet. Figure out they can pay for it some other way, even if they got to take out a loan. Let them figure out how to pay for it some other way. Do that the first year, do that the second year. The third year, use the college savings money that you've got. Will that be income to them? Yes. But by the time they graduate, year prior to the year prior, they will have graduated before that time comes back around. So as long as you only use the money that you put back for their last 2 years of college, you will not affect their financial aid in any way, shape, or form. So keep it in your name, pay for the last 2 years. And I would suggest paying for the last 2 years anyway. And y'all know why. Because about 3/4 of them are going to blow it the first year. In which case, all you did was blow off your money. Right? So, you know, if they're there the third year, hey, they're probably going to be there the whole time. So, you know, this is just everything. You get to keep your money. It's in your name. You get to pay for it, but only after they've proven that they're actually going to make it. So, anyway, that's the whole college savings bit. There's more to that if you're actually the parent. Like in our case, what we did is we just emancipated the children before they became age 18. Once they're an emancipated adult, their parents' income and assets don't apply towards financial aid anyway. And so it's just the kid themselves and whatever assets they have, and of course they're broke. So for financial aid purposes, our kids that are at Texas A&M are poor little orphan children. And you laugh, but that equates to about $7,500 a semester in financial assistance that we don't have to pay back. So take advantage of everything that's out there. So again, those are the ones that I knew ahead of time. Now imagine if I'd have had my parents adopt the kids, and not only would we have the government paying for it, then we'd have all this extra money for all the other stuff. Man, it would have been a heck of a deal. Anyway, finally we're going to get down to providing some benefits to those kids. Even if you're not planning on including your grandchildren in your estate planning, that doesn't mean it's not going to happen inadvertently. Right? You got 3 kids, and you're going to leave everything to the 3 kids, that's fine. Except that, what if one of them predeceases you? Most of the time, I would say the vast majority of people will say, well, yeah, if my child predeceases me, then I want their share to go to their kids. So all of a sudden now, your grandkids are in it. You don't ever want to just assume that the people you anticipate leaving stuff behind will be there. They may not. But you probably need to think through it a little bit. If you're leaving assets to a child, that child has predeceased you, and so that share is going to go to their kids, or possibly, depending on how old you get and how many generations, you may have multiple generations that have predeceased you, in which case some part of it could land into a great-grandchild or whatever. But the first thing with all of that is it's possible that it'll land in the hands of a minor. I got a call from another lawyer over in Fort Worth. It's a guy that I knew from law school, but he was calling. He said, "John, I've kind of got this weird situation. It doesn't seem right." He said, "I've got a family that's come in. Somebody has died, and they had named the child as a beneficiary on a life insurance. The child's 8 years old, and the child's got parents, they're married, but the insurance company will not turn the money over. The insurance company is saying they're just going to hold the money until the kid turns 18. And then they're going to hand the 18-year-old a check. And they're saying the only way around that is for the parents to go to court and get appointed as the child's legal guardian." And he said, "So they must be wrong, right?" And I was like, "No, they're right." And think about it, if you're the insurance company, so you're going to write a check for $100,000 that's supposed to be for little Timmy. But you're not writing it to little Timmy. You're writing it to little Timmy's parents, who take the $100,000 and go to the boats, figuring they can turn $100,000 into $1 million in one weekend. And when little Timmy turns 18, he doesn't have $100,000. And the $100,000 he has was squandered by these people. And little Timmy could actually turn around and sue the insurance company. And the insurance company knows this. And so they say, "Look, we ain't giving it to the parents. And we certainly can't give it to little Timmy because he's 6. And so the only solution then would be for the parents to go get court-appointed guardians. And the reason they go and have to get, even though they're their parents, the reason that the insurance company wants them to go through the court process is because once the court is involved in your life, they stay involved in your life. Which means once those parents go and get appointed as the legal guardian, the first thing they've got to do is file an inventory with the court. Here's what the child owns, $100,000. And then every 12 months after that, until that child turns 18, they have to go back and file an accounting with that court. Here's what the child had at the first of the year. Here's what we spent it on. Here's what income was earned off of it. Here's what we have at the end of the year, all evidenced by receipts. And if they want to spend it, they need to go ask the judge for permission. "Hey, little Timmy has turned 16. We need to get him a car. We want to spend money and buy a car." And they have to ask the judge and present the price of the car and what type of car and have a hearing on it. And the judge gets to decide, well, maybe that's the appropriate car for little Timmy, maybe it's not. But all of those protections are supposed to be built in there so that when little Timmy turns 18, he could go back through all of those court records and see where his $100,000 went and how it was spent. And all of that was supposed to be done under the judge's supervision, in which case, if it was squandered, the insurance company gets to sit back and say, "Not my deal. You had legal guardians, you had a court supervising it, you got a problem, take it up with them. We're clear, we did what we said." And if you don't want to go through all of that, then we're just going to hold on to it till the kid turns 18, and then we're going to hand little Timmy $100,000 on his 18th birthday. That sounds like a brilliant idea. I guarantee you hand little Timmy $100,000 on his 18th birthday. By Friday of that week, he's going to have spent it all on something red and fast. And probably with a removable top. And he's going to have a bunch of friends. And they're going to have a heck of a month. And then that'll be it. And it really wouldn't matter. So, The first thing is you need to say, okay, if this lands in the hand, so if you're talking about your estate planning, even though you may not plan on it landing in the hands of a minor, you need to have anticipated that and said, if this lands in the hands of a minor, then here's who I want to be in charge of it. So essentially what you're doing is you're creating a trust for the benefit of that minor. So you say, leave everything to my kids. If one of my kids dies, it goes to their kids. One of they die, it goes to their kids, and so on and so forth. And if this lands in the hands of anybody who's under whatever age, then I want this person to be in charge of it, or I want this bank to be in charge of it, or something. Somebody else who's in charge of it. Otherwise, you can run into this whole problem that I just described. So even though you don't anticipate it happening, you need to at least plan for it. And legally, you've got to make that where they can't get their hands on it themselves until 18, because that's the age of majority for legal purposes. But why in the world would you give something to an 18-year-old? I have 18-year-olds. They're morons of the highest caliber. Do not give money to 18-year-olds unless you just don't care what they do with it. There's exceptions out there. Even within our own crew, we have exceptions. But generally speaking, if you hand assets, so you might want to say, maybe 21, maybe 25, maybe 30. Some of that based on your own personal experiences, perhaps. By about 25, I was pretty much on the right track. By 30, I had sense. Anything before then is somewhat questionable. So you might say, for example, this bank or this person's going to be in charge of it until they turn age 25. And at 25, they could take over for themselves. Or you could say, at 25, the bank and the child will have to work together and agree on everything for an additional 5 years until they get to 30. And at 30, they can fire the bank and take over for themselves. I give them another couple of years there to get a little more sense, got at least a check and balance in there somewhere. So you want to plan for all of that, and that's pretty easy to understand. The one thing you don't have to worry about for most of y'all, I'm assuming, I'm making some broad assumptions, is the generation skipping transfer tax. You ever heard of it? Most people haven't. Back in 1916, when the estate tax was invented, the first time the estate tax came, it's not when it was invented, there was estate taxes, but not in the United States. But in 1916, the United States first created the death tax. And at that time, anything you had over $10,000 was taxed at 90%. Woo, yeah! Now, $10,000 in 1916 was a bunch of money. But not to John D. Rockefeller, or Henry Ford, or Andrew Carnegie. There was still a bunch of people that had a bunch of money. And even in 1916, you had millionaires, not very many. The millionaires in 1916 were kind of like billionaires today. You had them, there ain't a bunch of them, but they're out there. And the idea, if you had $1 million in 1916, to pay 90% in tax on $999,000 was not really all that exciting. And so when they started this gift tax, when they started this death tax, what all these super wealthy people would do, some of it created charities, like Andrew Carnegie, right? That's the reason you can go to Carnegie Hall. The reason you can go to Carnegie Hall is because of the death tax. That's how he got around it. The reason you have a Carnegie Library in Jefferson, Texas, is because that's how he was getting around that 90% death tax, was giving it all to charity. But the other thing a lot of them did is they just gave it all to their kids before they died. And then when they die, they ain't got nothing. Well, that worked until 1924. In 1924, they created the gift tax. And they said, nope, now if you try to give it away before you die, we're going to tax that. And so you try to give it away, we're going to tax it. You hold on to it till you die, we're going to tax it. And these super rich people said, okay, that's fine. But if you're going to tax it every time somebody dies, then I'm just going to give it to my grandkids or my great-grandkids. Because that way, you'll still tax it when I die, but you won't be able to tax it when my kid dies, because I'll have skipped them and gone on down to the grandkids. That worked until 1936. And in 1936, they created the generation skipping transfer tax. And this is in addition to the estate tax and the gift tax. And what this says is, if you're making a lifetime gift, or if you're holding assets at death and bequeathing them to what they call a skip generation. So if you've got kids and you're going to the grandkids, that's a skip generation. And so there's a whole separate tax on generation skipping transfers there. Now, when I started practicing, I actually used to do quite a bit of planning around the generation skipping transfer tax. Because at the time, if you had an estate valued at more than $600,000, so the value of your home and your assets and your life insurance policies and your checking and savings, if all of that went over $600,000 and you were leaving assets to a grandchild, you were going to get hit with the generation skipping transfer tax and never know it. Because who's ever heard of the generation skipping transfer tax? But most of that's bypassed us all now. You'd have to have an estate in excess of $11.2 million to have to worry about the death tax. So most of us going to slide right under that. And that's per person. So if you're a married couple, that's $22.4 million. So if I said 11.2 million and you got scared for a second, come see me. And after you come see me, let's double check. Because if you're married, it's doubled. So it's 22.4 million for a married couple. And so you don't have to worry about that. And the estate and the gift tax, that 11 million per person, that's also the generation skipping transfer tax exemption amount. So you could leave your grandchildren up to $11.2 million in total, not per person, but in total, without having to worry about the generation skipping transfer tax today. We're always one election from that changing. And again, I mean, just in the time that I have been doing this stuff, we have gone from a situation where about a third of the population was subject to these taxes, most of the time not knowing about it, to today, where approximately 0.0002% of the population is subject to these taxes. But, if y'all don't know, you know who else doesn't know about all this stuff? Reporters. They're not a smart bunch in the first place. Some of them are, but most of them aren't. And even if they are very smart, they're smart about things, not necessarily about complicated tax law. And people who do know stuff about complicated tax law are not reporters, and they're not writing articles about it. And so, oftentimes, when you see these proposals that will have these big tax changes in them, either good or bad, it's all about things that apply to most people and that are easy to understand. It's easy to say, well, from 2017 to 2018, we got rid of the personal exemption and replaced it with a $12,000 standard deduction. So instead of you getting to take a deduction for every member of your household, you just get to take one big fat deduction as a standard deduction. That's what they did. So that's the current law. But getting into all of this estate tax stuff is complicated. When they pass those laws, though, they almost always are sticking estate tax stuff in there. You'll never hear about it. So it is good to understand that if somebody's talking about taxing something or changing the tax law, you can almost always guarantee that there's something in there about the estate tax that is going to change. But you will have to dig very hard to find out what it is. Because, again, reporters don't even understand it. But for right now, most of y'all ain't got to worry about it. All right. Man, I don't know that I have much else. Y'all got any questions about this stuff? Any of this grandparent business? I mean, the main things I wanted to talk about were passing assets at death. And again, that's just planning for minors. Yes, sir?
What about a CD if you put the word or in it, leave you're the grandparent, leave the word or in it, the grandchild? How does that?
So your question is, you got a CD at the bank, and maybe you go over to the bank and you put that CD so that it's in your name or the grandchild's name. You have just made them a co-owner of that CD. 9 times out of 10, also in that contract, regardless of whether it says or and, doesn't really matter there. Because buried in the contract, it's going to say, whoever outlives the other one gets whatever's in that CD or that bank account. That can be a very easy way to transfer the asset at death, assuming they're an adult, because you can still run into this same problem if they're a minor child. You know, my kids all have bank accounts, even when they were minors, but they're all under my name, under my Social Security number, with them as a secondary, because they're minors. It has to have that adult on it. If it was just in their name, they could actually not be able to access their own account. So as long as they're an adult, that would be fine. It might be better, though, to name them as the pay-on-death beneficiary. That way you own 100% of the CD. They just get it once they have stepped over your body and handed a death certificate to the bank, and not a minute before. And I say that because if it says, you know, it's your CD, you've got all the money in it, you go to the bank and you make them a joint owner. And then that child does not pay their child support. The Attorney General of the state of Texas, or state of Arkansas, is going to take your CD to pay off that co-owner's unpaid child support. And bank accounts are about the easiest thing for the Attorney General to find out about. Because all they have to do, they've got an electronic system, and they can just basically type in a message, and that message will go to every bank in a region that says, you have to find out if this person has an account at your location. And then, poof, there it is. The IRS has the same kind of power. And so if that child or grandchild does not pay their taxes, the IRS is going to send out a levy order and say, hey, if this person's got any money in any bank account, that money now belongs to the IRS. And so, yeah, and there's not much, if they've already taken it, there's not much you can do to get it back. If it's just in your name and they're just a pay-on-death beneficiary, then they have no rights to it as long as you're alive, and that would shield it from their liabilities, at least while you're alive.
Do they also zap that for student loans?
Your question is, do they also zap that for student loans? They can. A student loan that goes unpaid, if it's a federally backed student loan, so your Stafford student loans, and those are most of them. So most of your student loans are backed by the federal government, which means the federal government has the power to collect those student loans. Three of the most powerful debt collectors out there: child support, taxes, student loans. In fact, those are the only 3 things that can get to a Social Security check. You could go get every credit card on the planet, run up the balance on every credit card you've got, not pay a dime on any of those credit cards, and none of those credit card people could touch your Social Security check. You can get into a car wreck, get sued, kill a whole bunch of people. None of them can get to your Social Security check.
What about annuity?
Could they get into an annuity if a person had an annuity?
Now, annuities are a little bit different, but generally speaking, they're going to be protected as well from most creditors. Yes. But Social Security is one of those that's federally protected. The only 3 creditors that can get to that Social Security check: child support, taxes, student loans. And of course, you might be thinking, why does somebody have unpaid student loans and Social Security at the same time? Well, one would be that person I mentioned earlier that's got $500,000 worth of student loans. They ain't never paying that off. Shit ain't happening. All right, so that's one. But the other is because you messed around and signed a guarantee on that student loan. Grandkid said, but Granny, I need extra money so I can go to school, and I'm going to do so good, and it's going to be awesome, and if you'll just co-sign on this student loan, then I'll get the money and I can go to school, and then when I graduate and get that great job, then I can pay the student loan back. Yeah, don't do it. Do not do it. There's no reason to do it. 0. Either you can afford to just give them the money. And if you can, give them the money. Hey, you ain't never getting it back. Let's be clear. Right? Yeah. No lie about it. You ain't never getting it back. But you can give it to them. If you can afford to give it to them and you want to give it to them, give it to them. If they do somehow give it back to you, lovely. Don't anticipate it. But if you can't afford to just give it to them, then why in the world would you subject your assets to that loan? Right? If you can't afford it, then you can't afford to obligate yourself to pay it, period. So either you can afford to do it, in which case just give them the cash, or you can't afford to do it, in which case don't do it. Simple enough. Somebody, yes, sir?
John, I first want to tell everybody so they can hear, I have a son, this is not a grandchild, but a son, who refers to you as Saint John Ross. We're going to put him on to the Hazelwood Act, and he will graduate in the summer from the A&M. And I want to personally thank you for it, but I have a question about it. He does get Pell Grants. He does get student loans. He has been told there is a housing allowance. He is a veteran. I'm a veteran. He said there's a housing allowance that is available. Is this true?
So your question is, and we're talking about your son, who he's an adult son, but also being prior military, he's been able to go back to school in part because of a Texas law called the Hazelwood Act. Yeah, in Texas has the Hazelwood Act, which says that a veteran who served, I believe, 2 years of active duty minimum, and was in Texas and has returned to Texas after their military service, has 150 credit hours available to them. It's basically free tuition at any state university in the state of Texas for up to 150 hours. And any that they don't use, they have the Hazelwood Legacy Act that says that veteran can push that down then to their descendants. So my daughter at A&M is going tuition free because of the Hazelwood, and then all the financial aid is on top of that to pay for the room and board and everything. So that's the Hazelwood Act. Your question, though, was specifically related to, you'd also heard that there's some housing assistance through the VA. Possibly, and it depends on the type of form. For example, one of the guys that was in my unit in the Marines, he lives just outside of Fort Bragg, and he's the financial counselor there at Fort Bragg for when people are getting discharged from the military, and he tries to tell them, how to fill out resumes and invest and write checks and do all the other stuff. And he has actually been able to, his home was purchased with assistance through the VA. He's actually been able to purchase a second home with assistance through the VA. So you have the Veteran Land Board in Texas, which has land set aside for veterans. As far as just actual housing assistance for the day-to-day stuff, I don't know specifically about. If there is, I don't know it. But I do know they have all kinds of VA loan systems, VA land that can be bought, and things like that.
Must you be a Texas veteran to qualify for this?
Your question is, do you have to be a Texas veteran to qualify for it? The law says yes. The Texas law says you have to be a Texas veteran, meaning that you entered the military in Texas and then returned to Texas. Now, I say that that's what the law says because there was a law student at the University of Houston who was prior military but had joined the military in another state. And then, of course, is now in Texas at the University of Houston Law School. And being a law student, he decided to file a lawsuit saying that it would be unconstitutional to deprive a veteran of this benefit just because they enlisted in the military in a different state. And the Houston court agreed with him. And that case has not since been appealed, and they have not redone the law in any way, shape, or form. So right now, if you are a veteran and you're in Texas, you can apply for the Hazelwood Act regardless of where you were originally from. The Hazelwood Legacy Act, though, I believe both the veteran and their dependent that they're passing the VA benefit would all have to be in Texas. So if you were an Arkansas resident, you couldn't pass that to a student just because they were going to a Texas school. Yes, sir?
Now, do they have the Hazelwood Act in Arkansas?
And your question is, do they have the Hazelwood Act in Arkansas? They do not. It's a Texas-specific law.
Is there anything in Arkansas that's
There's nothing in Arkansas. In fact, there's nothing really anywhere in the United States that is similar to the Hazelwood Act. Yeah, but yeah, just hop over that state line. And there may be all kinds of reasons to do that anyway. Who knows? Yes, ma'am.
I want to go back to the child. If you have legal guardianship of a great-grandchild, and they've been living with you for 7 years, can you get that Social Security?
So your question is, if you're the court-appointed guardian, if you're the court-appointed guardian of that grandchild or great-grandchild or whatever it is, can you get that extra Social Security? No. You have to be a parent. The only way you can be a parent is by adopting the child. So no, you cannot. Yes, sir?
Okay. If a person leaves money to a grandchild,
Mm-hmm.
and they name the child to manage the money up until that child gets of a certain age. Meanwhile, that child owes money to the parent from various deaths and all. Any way that person can hold what is owed to him out of that.
All right, let me see if I understand correctly. So we've left money to the grandchild, but the parent is in charge of it.
Right.
But this grandchild also owes money to that same parent.
Yeah,
And so your question is, could the parent use the money that they're supposed to be holding for the child to pay back that debt?
yes.
Probably, well, it would depend somewhat on the language that created all of this. Generally speaking, no. And here's the reason on that. Because what we're talking about is creating a trust here, right? And a well-drafted trust is going to include something called a spendthrift provision. And a spendthrift provision says that the assets that are in the trust cannot be forcefully used to pay off the debts of a beneficiary. This language, and there's special language for it, but this language in this spendthrift clause is what you can use a trust for to protect the beneficiary from their own creditors. So for example, if I set up a trust for you, and I put money in that trust for you, and it had a spendthrift clause in it, and you owed the IRS cannot get to that money. If you had credit cards or you filed bankruptcy, they cannot get to this money because I have protected it so that it is just for your benefit. Now, once it comes out of the trust and goes to you, How you use it, if you used it to pay the IRS or something, it's fine. But I'm supposed to be holding this for you, and particularly in a way that would not be subject to your creditors. And so even if one of those creditors was the parent, and I have as so often is the case, I have stories. So I had a lady, she had set up a trust for her son, put money in that trust. It was managed by a bank. The son then also stole $60,000 from mama. He was criminally prosecuted for that. And as part of his sentencing, he was ordered by the court for restitution. He had to pay her back $60,000 because that's what he had stolen from her. And of course, there's more than $60,000 in the trust that she set up with her own money. Was not available. I actually represented the bank that managed that trust, and I was like, y'all can't have it. I'm sorry. And I explained all the laws and everything, and the very, very angry district attorney who was blaming me for it. But I was like, look, we can't do it. And the court can't do it. But we certainly can't just voluntarily do it because then the beneficiary could turn around and sue us. I was like, so it's just not going to happen. And they were not happy about it, but that's the deal. So generally speaking, I would say no. And if the person did use that money to pay themselves back for that loan, then it's possible that the beneficiary could turn around and sue them for breach of their fiduciary duty. So they're not supposed to think about themselves. They're only supposed, when it comes to that trust, they're only supposed to think about what's in the best interests of that person.
I think you answered my question pretty thoroughly there. Right. One other question. Again, the child has, manages it for the grandchild.
Uh-huh.
At the point where they can give it to them, are they allowed to hold it up and not give it to them?
So your question is, so they've got the trust, they're gonna give it to them, but they're gonna hold it in some way, shape, or form?
That child cannot get it, whether you're gonna pay me back the money you owe me, or you're not financially responsible enough to handle this.
So what they could probably do in this situation, they've got this debt, and I'm assuming the debt is unpaid or something like that. What they could do, if they really wanted to do it just exactly right, that parent would have to turn around, sue the child. And of course, for breach of contract or whatever it is, they would win that, presumably. Once they won that, they could reduce that judgment to a lien and go and record that lien, and they would have a judgment that is now a lien on anything the child has. Now, when they make a distribution out of that trust, that lien would immediately attach to it. And so then they could levy on their lien and collect the money back. The question becomes, though, if the trustee knows that the beneficiary has a lien against them, is it a breach of their duty to even make a distribution that's going to get subject to that levy? So probably not. What they might want to do in that case is resign as trustee, appoint a bank or somebody else, and then go out separately and attack the beneficiary to get the judgment and everything like that. But anyway, that's a messy mess right there. Yes, sir.
John, with all of these complex laws throughout the nation and all you talk about, why would anybody ever want to become a lawyer?
Yeah, why would anybody ever want to do this as complicated as it is? I have no idea. You've just got to be weird enough to enjoy it. And we do. I find a lot of this stuff just terribly fascinating, and I know it bores a lot of people to death, but I find it terribly fascinating. So you're just lucky there's nerds like me around. Yes, sir. Last question.
On this Hazelwood law, I was drafted in 1951. My draft was in Louisiana, but adjourned in Texas, that's San Antonio, Texas. And by law, I had to get discharged in San Antonio, Texas. Now, what is the limitation? Why, if I move out of the state, say, what is the come back in, how long you have to be here to be certified Texas resident?
So your question is, you actually were although you were drafted and weren't a resident of the state, you went to San Antonio. That's where your what they call the MEPS, the Military Entry Processing Center, was. That's where you were discharged back to San Antonio. And if you moved to Texas, how long would it be before you could use that Hazelwood benefit for yourself or pass it on to somebody else? I don't think there's any time. I think you just have to establish that you are currently living. That you've got your voter registration card, you've got an address, you're paying utilities, all in the state of Texas. All right. Well, listen, I appreciate y'all letting me run my mouth. We'll see y'all next time. They'll pass out some door prizes.